Welcome to the latest episode of Risk Settlements Podcast, Alternative Litigation Strategies, where I interview legal leaders in the litigation industry from top firms and companies from around the country. On this program, we discuss the latest trends and developments that are currently happening in the world of class action and other types of commercial litigation. I'm your host, Kevin Skrzowski, with the litigation consulting firm Risk Settlements, and today I am pleased to be joined by Stu Richter, a class action and consumer finance litigation partner in the Los Angeles and Century City offices of Katten, Muchin, Rosenman, and a Chambers-rated attorney in financial services regulation for his work in consumer finance litigation. Stuart, good morning, and thank you for joining.
Good morning, Kevin. Thank you for having me.
Stuart, perhaps we could start just by having you tell us a little bit about your practice and your lengthy career at Katten.
It is a lengthy career. I'm one of those attorneys that started at a firm and I never moved. I began practicing in 1986. The firm that I started with, which was a large regional in LA, dissolved. And what was left of that became Katten in 1991. And I've been at Katten ever since. So for that 30 plus years, I've been doing consumer finance related litigation. I started out in that area and it gradually developed from small consumer finance cases up to now. I'd say 90% of my practice is defending large class action cases for consumer finance companies.
Now, I know that you have a very particular deep experience representing banks and credit unions and other financial institutions, especially in overdraft litigation. For those that aren't completely well-versed in this area of law, what is overdraft litigation, and what are some of the latest theories that are being advanced by plaintiffs?
It's a big area, and it's been a big area for probably 10 to 15 years, and you'd think my clients would learn. But I don't like to call it overdraft litigation. I would say it's bank fee litigation. It really addresses all the various types of fees that a bank may charge. Some of those are overdraft fees. Some of them are, for example, when you draw money out of an ATM or you make an electronic transfer. So those are all parts of this case.
All the different various types of fees. You're correct, right?
Yeah, but primarily it is overdraft fees because those are the easiest ones to attack. And the theories, it's very interesting because there's probably about 10 theories out there for these cases. And I'd say there's three main theories. And they all center around the balance that a bank uses to decide whether to charge an overdraft fee. Now, not many people know this, Kevin. I don't know if you know this, but your checking account has two balances. There's a current balance, which is what you see on your statement. And then there's an available balance, which is behind the scenes. So the available balance is basically your current balance minus if you deposited a check and it's not all available right away. The bank deducts for that. Or if you use your debit card at a store and you swipe that card and it's authorized by the bank will deduct for that. So the available balance is less than the current balance. And so these theories, the overdraft bank fee theories, really are attacking when the bank assesses an overdraft fee and what balance it uses to assess overdraft fees.
So this is a moving target based upon your activity on that given account on any given day.
I would say that that's accurate. And remember, these theories and the plaintiff's lawyers, they're very, very good and very creative. I give them their props on this, is that they're not challenging overdraft fees and saying, hey, they're unfair or unreasonable. And they're not challenging the fees and saying, you didn't disclose it well enough to me when I would get a fee. They can't do that because those kinds of claims are all preempted by federal law.
Right.
The claims that they make are that, bank, you actually breached your own account agreement because your account agreement says you will only charge me fees in specific circumstances. So by using the available balance, or by charging me a fee on a debit card, or by charging me a fee when a transaction is rejected and represented. Your account agreement says that I won't get a fee there. So all these theories boil down to a breach of contract, a breach of the bank's account agreement.
Of their account agreement, their customer service agreement that they have with the bank. So you're saying it's not the amount of the fee, it's when the fee is applied.
That's right. The plaintiff's lawyers can't really challenge the amount of the fee. Now, a regulator or the government, a state regulator, if you're regulated by the state or the federal government or the FRB, may say someday that there's a cap on fees, but that's not something that the plaintiff's lawyers can challenge in these cases.
Because as the consumer, you've already agreed to bank at that branch and you've agreed to accept that fee should an overcharge or an overdraft occur.
That's right.
Have there been situations where the fees have been deemed to be egregious? I would guess if they're in violation of law, or established amounts.
None of these cases allege, some of them, if you violate a regulation that provides for a specific type of disclosure, and sometimes these cases involve that, but generally they're saying, bank, you said you wouldn't charge fees in these circumstances, and I got a fee. And it's really based on a plaintiff's lawyer's, what I would argue, idiosyncratic interpretation of the account agreement. So The account agreement may say X, the plaintiff's lawyer says no, it says Y, you're not going to charge a fee, and that's the basis for these class actions. That's the theory.
Understood. Now, you said that this type of bank fee litigation has been occurring for about 10 to 15 years. In my business, we do a lot of litigation consulting, a lot of insuring of class action settlements. And so I've seen them ebb and flow, and I feel like there's been a steady increase over the past couple of years. And in most of the industry journals that I've read that the fees are at an all-time high. But now, we had the conversation that it isn't necessarily the fees, it's when they've applied, but still there's a lot of articles that are addressing like the size of the fees or maybe a record amount of fees being charged. And I was wondering if that does somehow play into some theories and increase the stream of litigation if banks have been proactively doing things internally to curtail this.
Okay. Yeah. And that's a
couple of pieces there. Yeah.
That's a very good point, is that a lot of banks and credit unions and the banking industry as a whole is under the microscope from regulators and certain politicians. I think Senator Warren calls overdraft fees junk fees. And so there has been a lot of criticism, and there have been studies that have indicated that, these fees are, there's billions of dollars of fees charged every year. So that's certainly fodder for the regulators and for the politicians.
That the aggregate amount of these fees that is being charged nationally has been increasing. Right.
But you can attribute that, Kevin, to a lot of things, not necessarily an increase in fees, because I've seen most of my clients, and I represent hundreds of clients across the board, have been decreasing the cost of the fees. There's been a lot more economic activity, a lot more checking account activity, a lot more money in the system. And what you see is a lot of people use overdraft programs at banks to manage their finances, right, in lieu of payday loans or more expensive financial products. So I can't say for sure why the overall fee revenue has increased at some banks, but there's a lot of factors that go into it. And sometimes to just say that there's more fees out there is a bit misleading.
Understood. And that makes perfect sense.
But to your point though, Kevin, it certainly is something that it creates a perception, and it puts a nice big fat target.
It really does. Well, it creates a perception among the consumer class that there's a victimization and a victimhood by these big, large financial institutions who we've heard for years, they get government bailouts, and that how dare they charge this individual person this fee when I'm just doing my daily banking activity. So while they may not have a legal cause of action, you're right, it is fodder for regulators. and it does create a misperception among them in the marketplace, really.
And it certainly makes its way into, it can't be the basis of a claim by a plaintiff's lawyer in one of these class actions, but it's certainly good for 3 or 4 paragraphs in every complaint
Right.
about how the banking industry is raping and pillaging the average consumer.
It's a nice tee up in the introduction to causes of action, which you have to respond to. So moving on, to individual defenses. So let's say you're representing your bank or your credit union in one of these types of matters. You have one of the top 3 most commonly argued natures of suit, as you had mentioned before. So what are some of the most effective defenses to these types of claims? And what are some of the considerations that go into what you include in your motion to dismiss?
Good question on there. And obviously, and we'll get to this in a little bit, I know, and we'll talk more about it, but the first and best defense is still arbitration.
Okay.
If you can lead with that, you're good. And in fact, that will dissuade most plaintiffs' lawyers from filing a case if your account agreement has an arbitration provision. So that's number one, and we're going to talk more about that later.
Yeah, sure.
But number 2 in all these cases is because, as I said, they're based on a breach of the account agreement. So you've got to look at the language in that account agreement. If the language is broad enough and says, we're going to charge you a fee every time you overdraft your account, I've had success getting cases dismissed right at the outset because the plaintiffs are alleging breach of contract. They attach that account agreement to the complaint. And so it's right for a motion to dismiss if you can get there. That's the second best attack. The third best attack in these cases is the individual plaintiff. Many times, these plaintiffs, they know well why they're overdrafting their account. And some of them do it with purpose. For example, I took a deposition of a plaintiff last week in one of these cases. And the plaintiff was actually writing checks to him or herself. I won't say any names.
Understood.
Writing checks to him or herself to raise the balance of the account, and then using their debit card or the ATM card to take money out, generating overdraft fees as a result of that because they could take it up to their overdraft limit until that check bounced and the account was reduced to even a further negative balance.
So they're borrowing from Peter to pay Paul, hoping that these 2 ships pass in the middle of the night and never quite cross at
As
the
I said,
end.
many of these plaintiffs use the overdraft privilege program to balance their checks and make their finances. This particular plaintiff was actually kiting checks and increasing the amount of money available. So that's the third kind of defense in these cases. A lot of times these plaintiffs know exactly what they're doing. So while the plaintiff's counsel may argue they're confused, they thought they were not going to get a fee based on the language of the contract, when you talk to them in a deposition, you find out they knew exactly what they were doing. And it's the people that get fees a lot that know the most.
Okay, so you have some of the more usual suspects who are trying to game the system and leverage the different ways they can access their funds to manipulate it. Now, what about a situation where, and I know I have an overdraft program that I pay for, I'll be notified of an overdraft, but if I rectify within a certain period of time, I actually don't incur the fees. Are you able to sometimes dismiss plaintiffs who believe they did, but maybe actually didn't incur fees?
Yes, a lot of times the plaintiffs will allege in their complaint, the named plaintiff, that they got a fee in a certain situation. And again, this goes to that third defense. You do an analysis of the plaintiff's account, and sometimes you see that, hey, the next month, the fee was actually refunded because they called up and complained about it. Or they say it's a particular kind of fee and it really wasn't. So that happens quite a bit in these cases.
And then that leads to a successful motion to dismiss?
Yeah, if you're in federal court, we make a motion, not only a 12B1 motion based on a lack of standing, where we can put in evidence and say there was no damage incurred here because the fee was refunded. So it's not a 12B6 traditional motion to dismiss. It would be a motion to dismiss for lack of Article 3 standing.
Understood. Okay. So now let's say the plaintiff's claims survived the motion to dismiss phase, and you're moving on to the portion of the case where you're looking at doing a liability and a damages assessment. You believe there's some culpability on behalf of your client. At what point do you consider settling versus continuing defend, including maybe taking a case to trial? And do any of these types of cases actually make it to trial?
I have not taken one of these cases to trial, and I'm not aware of any that have gone to trial. And I keep pretty good tabs out there, so I don't think they go to trial. I mean, class action cases rarely go to trial.
About 2% maybe.
Yeah, maybe. And in terms of settlement, from the beginning of the case, I'm always evaluating the total exposure, because I want my client to be able to balance the total exposure, and I give them assessment of the potential liability and the potential success. If you lose a motion to dismiss, I want them to know exactly what the potential exposure is. So settlement's always a consideration, but you're right. If you lose a motion to dismiss, it becomes more of a consideration, because now you're into spending money. You're moving on to class certification, summary judgment, potential electronic discovery. So that's something that we do look at. And if I don't hire an expert, I usually have enough knowledge in these cases, because I've done so many of them. I can give them a pretty good ballpark based on the size of the institution, their overdraft revenue, et cetera, of what they're ultimately going to face if they lose the case. So settlement plays a big part in it. And I'll make this point, Kevin, that sometimes you do in these cases, they're filed, and every bank and credit union is different in terms of how they process fees, when they refund fees. I've had cases against fairly large institutions, and the plaintiff's lawyers get dollar signs in their eyes when they find a good plaintiff against a big institution. And you do your analysis of the potential exposure, or you hire an expert to do it, and it turns out there's no money there. For whatever reason, they just refund the fees. They don't charge the fees. Their practices are different. There's no money there for the particular kind of fee. Yeah. And those are cases, a lot of them settle individually.
Right. Well, in our business, we insure a lot of claims made class action settlements. That's our core. So we're always looking to get a full nationwide release and pay the class an equitable distribution of an agreed upon benefit to each member who opts in. But you're right. Sometimes if you can settle on behalf of the named plaintiff, it's the most efficient exit to that particular matter. In some. And we'll often counsel clients when we speak with them as well. But you have to always be wary of a copycat lawsuit. Most of the usual suspects know who the other people are. We all read the same industry journals. We'll see if the case against this particular large bank or this client is dismissed. And there could be another plaintiff's lawyer in a different jurisdiction who finds a named plaintiff and refiles tomorrow. Doesn't happen very often, but it's always just a cautionary tale and a caveat.
And I'll disagree with you a little bit there, though, Kevin. I have seen that happen a lot in these bank cases. There's 4 or 5 groups of plaintiffs' lawyers out there, and I've seen one sue for one theory. And if you settle individually, you'll see another one suing for another theory. And so that, you're right. It's always a consideration. If you do an individual settlement, your client has to understand that there's potential there. And the way you deal with that, and I know it's an issue you want to bring up and talk about, is fix. Part of what I do in every case is to fix the client's disclosures so they're not going to face any other claims, and implement an arbitration provision so that if another case does come along, we'll be able to deal with it that way.
So let's go back to that then. I know you had mentioned that's a great defense, or that's a more of a compliance issue to counsel your clients on in hopes of avoiding a lawsuit. But how effective are the use of arbitration agreements by banks and other financial institutions in their customer contracts to stave off litigation, particularly class action litigation?
I think if they're implemented properly, and remember, if you implement an arbitration agreement to your existing customer base, you've got to do it right. If they're implemented properly, I've had almost 100% success with courts, state and federal, across the country, enforcing an arbitration provision in a class action case.
Now, you say implemented properly. Like, what are the key things you have to make sure that you don't leave out?
Well, some state courts, they don't like arbitration, and they'll do anything they can to avoid it. If a customer has signed up for electronic notice, they want to get their statements and notices electronically, send them the notice of the implementation of the arbitration agreement electronically, exactly the way they want it. And when you send them that email, put right on the front of it in the subject line, important change in terms, arbitration. You have a right to opt out. Always give them the right to opt out. Because the argument there is, the plaintiffs will say, well, you foisted this arbitration clause on them. My response to that is, no, I didn't. I made an offer to them if they wanted to arbitrate. If they didn't want to arbitrate, all they had to do was write us an email or call and say, I hereby opt out. And look, hundreds of other people did just that. Mm-hmm. So that's when I talk about implementing it properly. You've got to beat them over the head with a notice, and you've got to give them that right to opt out.
So that they know, they're aware, and they have the opportunity to do so. They've been afforded every chance and opportunity, then they can't argue around it.
That's right.
Okay.
That's right. And you can't do an arbitration clause for an existing claim. That doesn't work. So I don't want anybody in the audience to think that that's a silver bullet for a pending claim. That's not going to work. This works for new theories, new claims, additional claims.
Understood. So sticking with that then, how do you counsel clients, or do you work with clients when they're creating their customer agreements? Do they come to you to make sure that they're drafted in accordance with compliance of certain law, like let's say the Overdraft Protection Act of 2021? And how much of your practice is dedicated to that, to staving off litigation at the very onset? Or in doing, I would imagine you do periodic reviews of customer agreements as well.
Yeah, if you're a client of ours and we handle the litigation, there's two parts to that. It's obviously dealing with the litigation. The other part is fixing the issues. I also have many clients that are represented by other counsel for the litigation, and the lawyer refers them to me to work on fixing their disclosures and implementing an arbitration provision. And then once I have those clients, I get emails every day or updates or questions. For example, I'm representing 3 clients right now that have called me and said, hey, we see what's going on in the world out there with overdraft fees. Can you give us some advice on what best practices might be? What kinds of things can we do so that we're, outside that target area of the regulators and the class action lawyers? So I'd say probably 10 to 15% of my practice is prophylactic like that. It's preventive maintenance.
And it sounds like the smartest institutions are almost doing a continuous review of the terms of these agreements to make sure that they are following best practices. So,
yeah, I think you've got to be out there, and either you have a lawyer like me or your lawyer or your in-house compliance people have to be monitoring this stuff. It's easy to see trends. And one of the things we do for our clients, I monitor class actions that are filed every day. If I start to see a trend in an area, I send them all a notice. Say, look, this may be coming down the pipe. Go look at your disclosures.
Here's a new theory. Let's look at your disclosures. Make sure they cover what this potential new theory could be.
That's right.
Ounce of prevention is worth a pound of cure, right?
Yeah, I may be cutting my own throat because I'm,
avoiding future litigation and
exactly.
But yeah, no. But I think that solidifies the attorney-client relationship very well, though.
Yeah, but my kids had to go to college too. So
well, sure. So very interesting. I think that's all great advice. So of course, my business here at Risk Settlements, we're focused a lot on actually class-wide settlements. So let me ask you a few questions about that. So how are the settlements in these matters usually structured when you do settle on a class-wide basis? And have you found certain structures to be more effective than others?
Yeah, and I know your business, Kevin, but I'm sorry to say that most of these cases settle on a claims paid basis. not a claims made. There are hybrids in this,
Sure.
where there's some claims made and some claims paid. But because they're bank customers and because we can pretty much identify who got one of the offensive fees, we usually hire consultants to create the damages list, and it's paid out to everybody. They're either sent a check, or if they're an existing customer, they get a credit to their account.
Because you know exactly the amount that every individual was paid, and there's an electronic record, and it's calculable.
Correct.
Which makes complete sense, right?
Now, but if we have a case that alleges, for example, a regulatory violation or something like that, we have hybrids where there's a claims made component to the settlement. Now, unlike the settlements that you insure, where, and I recognize the kinds of cases you do where you don't really know how many people are going to make a claim, we sort of know the universe of potential claims. And there's an allocated amount of money to the claims made component of the settlement.
Yeah, no, very interesting. And I think that makes sense. And there's certain types of cases that we insure every day, and then certain types that we rarely do. The ones that are rare are like this, or securities types of cases where the benefit of the damage to each individual class member is calculable and it's supported by evidence. So that all makes complete sense. Wrapping up here, Stu, is there just any final comments you have about bank fee litigation, the future of litigation, things you see coming down the pike for this year or next that people should be on the lookout for?
I think these cases started since 2008, back when we were doing the resequencing, where banks were doing the high to low, and it's progressed. And I still see dozens of these cases filed every month across the country. So my advice out there to anybody who's listening is go take a look at your disclosures and look at what you're charging your customers. They better match.
Right.
You better accurately describe what you're doing, or you're a target.
Do an audit. Make sure.
Yeah, I don't see this stopping. It's slowed down, but I don't see it stopping. And when it does, there's going to be some other theory related to the fees that are charged by banks and credit unions. That's never going to go away, and you've got to stay on top of that. My advice would be to monitor what's going on out there and stay on top of it.
I think that's great advice. And with that, I think that's about all the time that we have here today. Stu, it was a real pleasure having you as my guest, and I want to thank you for your time and all the valuable insights that you share with me and our audience today. Thank you.
Thank you, Kevin. Take care.
Now, if anyone would like to contact you to discuss any of the topics that we covered here or any of the matters that you handle in your practice, what would be the best way to reach you?
I would say send me an email to my work email at Stuart, Stuart.Richter at Katten, KATTEN.com. Or you can always call me. My office number is 310-788. My direct is 4582. 310-788-4582, or look me up online at Katten's LA office. I'm happy to respond.
Sounds great. Thank you, Stu. And of course, as always, I'd like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program or would like to learn more about class action settlement insurance, litigation buyout insurance, or other litigation risk transfer vehicles that are available for all types of class action and commercial litigation, please visit the Risk Settlements website at www.risksettlements.com. And you can always reach out to me directly at kevins@risksettlements.com or my direct dial 216-570-9370. Until next time.